Wait a minute. So if you pull your gun, you should be prepared to go to jail.
Yes. Yeah, a lot of people think gun law is just like stand your ground. Obviously, that's kind of the bread and butter of it, but there's so many things that are tied to Second Amendment stuff. Or who have a
You
permit.
can't conceal a firearm.
What's the number one rule of guns? You don't pull your gun unless you intend to use it.
What about the home gun range thing?
You've all heard the phrase yard pop. When you're doing a stand your ground, it's both subjective and objective. And stuff or like something like that, right? Yeah.
Yeah, is that legal?
No.
Can you say that again? Did that guy ever get charged?
No, because they couldn't prove who.
What's going on and how are you? My name is Will Meade and welcome to Shark Coast Tactical Podcast, episode 10. This week we have a special guest. We have Jeffrey Young of the MinnesotaGunLawyer.com.
How you doing?
Thank you very much for coming.
I don't know. Am I supposed to talk? Okay. Let me know when you want me to say stuff.
Absolutely. So also I have my homies. I have the amazing Dean Carroll.
Down on the end, one and only.
We brought back Luke Andrews because he was so much fun the first time.
What's up?
And Pierce Stroud.
How you guys doing?
Back in the flesh. So Jeff, tell us a little bit about you. Where did you come from? What is it exactly you are in Sarasota?
Well, I came from my mom's vagina originally.
God bless.
I don't know. Are we? I don't know. Are we allowed to say things like that on the show? I don't know.
Do whatever you want, man.
Right. So I'm local. I was born right here in Sarasota, right at Sarasota Memorial Hospital across the street. I was born and raised in Venice. Went to Venice High. Went to UCF for a criminal justice degree. Then I got my law degree at a small little school in Topeka, Kansas called Washburn University. As soon as I graduated from there, I came back to the Sarasota area where my whole family lives and where I was raised. Got a job at the state attorney's office, was a prosecutor for about 6 years at the state attorney's office, then figured out I don't like people telling me what to do. So I quit the state attorney's office, and now I run my own business. It's the Young Law Group is the official legal name of it, but I go by the Minnesota Gun Lawyer. That's what people call me. You can find me at MinnesotaGunLawyer.com. I also have a YouTube channel. Musings with MGL is my YouTube channel. I couldn't call it Minnesota Gun Lawyer because the algorithm would F with me on that. So I go by Musings with MGL on YouTube. But basically, I have a law firm here in town in Sarasota. My office is over on Tuttle and Fruitville, and I practice mostly criminal defense. So I have a criminal justice degree. I work at the state attorney's office. So now I'm a defense attorney, so I handle criminal defense cases. I do some divorce as well. So if anybody needs divorce stuff, they can call me as well. But what I really like to do, what my passion is Second Amendment law. So I do all kinds of Second Amendment cases. I do self-defense, stand your ground cases, restoration of firearm rights, red flag laws, risk protection orders, injunctions. I can get old Baker Acts cleared off your record. I help people who get turned down for firearm purchases when people try and buy a firearm and they get denied. If they need their background cleaned up or they want to appeal that. Concealed carry permit denials. I deal with the Department of Agriculture all the time. So basically anything that's Second Amendment related, people can call me and I'll help them out.
So you do a bunch of shit.
Yeah, everything, it sounds like.
Yeah, a lot of people think gun law is just like stand your ground. Obviously, that's kind of the bread and butter of it, but there's so many things that are tied to Second Amendment stuff. Like if you've, again, an injunction, somebody tries to file a domestic injunction against you, that makes you a prohibited person. You can't possess a firearm. If you have a red flag law, these new risk protection orders that came out, you get one of those against you, you can't possess a firearm. You got an old felony from the 70s or 80s or something, you've served your time, you're still a prohibited person, you can't purchase a firearm. So there's all kinds of ways to fix all that stuff. I can fight your domestic injunction. I can even get them removed if they're still on your record. I can fight risk protection orders and red flag laws. I can get those removed from your record. If you have old felony convictions, there's a restoration of rights process in the state of Florida that I can help you go through. So basically, I get calls about everything from can I smoke marijuana and have a gun? I got denied a purchase and gun shop gave me your card. My ex is trying to get an injunction against me. I have an old felony conviction from the 80s and now the world's going to shit and I think I need to have a gun and I tried to buy one and I can't. So what can you do for me? So yeah, that's pretty much runs the gambit.
So you're like 6 episodes worth.
Yep. Jeff, the guy just shot a guy lawyer.
Yeah, right. I'm not just a shot a guy lower. There's a
So-
lot of stuff. So that's why people go to my YouTube channel. I'm not promoting my own stuff on your show, but it is a YouTube channel. I'm using with MGL. I've done all kinds of episodes on this. You can look at my backlog. It's been up for a couple of years now, but I've done episodes on restoring your rights, risk protection orders, Baker Acts, firearm denials. I keep up with the current law. So any new case law that comes out, I always crank out a video on that. Any new law that gets passed, I crank out a video on that. So if people like and share, subscribe, whatever to my channel, they can really keep up with all that stuff. Or they can call me too. I don't generally charge a fee for just generic questions. So if you shoot me an email, if you go to minnesotagunlawyer.com, you can send me an email. If it's like a generic question, can I have a marijuana and a gun? I don't charge for that. I'll answer that. If you have a specific question like, hey, I have an old felony, how do I get my rights restored? You know, I'll charge a consultation fee or whatever. I can answer those
I
questions.
have a
for you as
specific
well.
question.
Okay.
Okay, so episode 4 we did 6 weeks ago. We got into an issue. Meaning like we said something and fucking TikTok went ballistic. Like the
Is this the brandishing thing?
the brandishing thing. So we wanted, like, when it went down, TikTok, like the post kind of went viral, and because people were pissed because they thought we were giving out the wrong information. We had people send us the law, and I just remember what you told me, and so I was remembering what you told me back when I called you for some legal advice, and I was like, "This, I don't think you can do this." So let's just ask, what exactly are the laws pertaining to, and what is brandishing a firearm in the state of Florida?
Sure. Well, brandishing is like a slang term. So if you look up
Okay.
the statute, you won't find the word brandishing. Technically, what it would be is what's called improper exhibition of a firearm. So it's a misdemeanor in the state of Florida, and it basically requires you to basically display your firearm for no proper reason, like you're just waving it around, being negligent with it, et cetera, et cetera. So that's called an improper exhibition of a firearm. It could also lead to an ag assault, though, so it depends on what the situation is. So what happens is, here's a classic case. Like, I get these all the time. Road rage incident. Somebody's
Okay.
driving down the road. Somebody else is running them off the road. They're fighting or whatever, road rage. And people start cussing at each other. And somebody pulls a gun and they like show it to them through the window or something like that. Hey, don't F with me. I got a gun. And so then the person drives off and calls the cops and said, hey, they were waving a gun at me. That's not going to be legal unless you can say that it was self-defense, a stand your ground situation. You were in imminent fear of threat or death or great bodily harm. Just waving it around is going to get you probably an aggravated assault with a firearm charge. So an aggravated assault with a firearm charge is, I'm using the gun specifically to put you in fear that I'm going to use the gun. So again, improper exhibition. I'm standing in my front yard, New Year's Eve, woo, country, cowboy, whatever. You can get an improper exhibition for that. That would be slang for brandishing. If I'm doing that in a car and I'm saying F you and I've got a gun and the person feels threatened or in fear, now you can get an ag assault for waving that gun around. So it could be illegal. It could also not be illegal. It depends on, like everything, it depends on what the facts of the situation is.
Do you recommend doing it?
That makes sense. No, I never. Look, what's the number one rule of guns? You don't pull your
Pull it
gun unless you intend to use it. So if you intend to pull it out and shoot the person, then pull it out and, you know, shoot the person if you have to. If you're just pulling it out to scare the person off, that's going to get you an ag assault charge. If you're pissed and just pulling it out
hold-
because you're pissed,
So hold on.
that's going to get you an ag assault
So
charge.
TikTok is convinced that you can, and people are convinced that you can pull it out. It sounds so dirty. TikTok and people are convinced that you can pull your firearm out if you feel your life is threatened. But so you can.
You can.
But you're saying you will get an ag assault charge because it has to do with facts. And will the officer arrest first, ask questions later, or ask questions and arrest you at the same time?
Usually, yeah, they'll usually arrest you first and then ask questions later, especially if it's a firearm. So the answer is yes. If you are in imminent fear of death or great bodily harm, or you're trying to prevent a forcible felony such as carjacking, rape, etc.,
Stabbing.
then you can pull your firearm out and you can either use deadly force or threaten to use deadly force because you're in imminent fear of death or great bodily harm. Whether you're in actual imminent fear of death or great bodily harm is going to be a subjective thing that the cop is going to decide when they show up at the scene to see if you were justified with pulling it. And then it's something that the prosecutor is going to decide whether they thought you were justified. It could be then up to the judge, and it could be then up to the jury. So, yes, you can brandish your firearm, meaning pull it out and point it at somebody, but you better be in imminent fear of death or great bodily harm or attempting to stop a forcible felony. If none of those things occur, then you're going to get charged with aggravated assault.
And you can get arrested anyway, even if it is occurring.
Correct. Even if you're correct, that's why we have the stand your ground law in Florida, and there's motions you can file to get them dismissed in front of the judge. You can certainly have cases where you at least always feel like you're justified. Like, I never have anybody in those road rage incidents come to me and go like, yeah, I was stupid, I shouldn't have pulled out my gun. There's usually something like, I thought they had their own gun, or they were cussing at me, or I had my children in the car, or whatever. They're always justified in what they do in their own mind. But it's an objective standard. It's like, what would a reasonable person do? So even though you may think you did everything correctly, if the cop shows up and doesn't, his personal opinion, he thinks that you didn't, he's going to arrest you for aggravated assault. And then it's going to go to the state attorney's office, and the prosecutor is going to look at it. And the prosecutor, in his mind, thinks that you weren't justified in doing it. They're going to file the charge against you, and then you have to get an attorney, and you got to file a stand your ground dismissal motion with the judge, and maybe even go to a jury.
Well, so were you going to say something first?
The Marine Corps uses what you said, a normal person, or how'd you phrase it?
Reasonable person.
Reasonable person. They use that verbiage in the Marine Corps definition for it.
Yeah.
As well, the definition for deadly force.
Right. It's both. So when you're doing a stand your ground, it's both subjective and objective. So there is a subjective nature to it, because if you have the person tell the cops in an interview.
Dummies at home like me, what the fuck is the difference between subjective
so
and objective?
subjective is me as an individual. Let's say I'm an 80-year-old man, and the person against me is a 30-year-old man, and I am subjectively, meaning me individually, I'm afraid of what he could do for me, so I pull out my gun. That's a subjective fear. Objective fear is I'm not the 80-year-old man. I'm a reasonable, average Joe person on the street, and I'm looking at it outside that situation and saying a reasonable person in that same old man situation wouldn't have pulled out a gun. So every time somebody pulls out a gun, they always say that they are in fear. I was in fear personally, subjectively, what was going to happen to me. But then a jury comes in and looks at it not as if they were that person. They look at it as if they were a different, objective, reasonable person, saying that even though you may have been in fear, a normal person on the street wouldn't have been in fear. Therefore, you couldn't have pulled your gun.
Oh, fuck.
So it requires both. Because if you pull your gun and shoot somebody and they interview you and say, I wasn't scared of that asshole, I just wanted to shoot him, you got no subjective fear. Right. So even if there's an objective fear, let's say he was coming at you and attacking you, but you tell the cops, I wasn't afraid because I have training from the Marine Corps or whatever, so I just shot him. Well, then you're going to have a problem because you don't have subjective fear. Or if you have a situation where you feel that you're in fear, but let's say there's witnesses or a surveillance camera that shows the guy was 15 feet away from you, he wasn't really doing anything to you. You can say all you want that you were afraid, but objectively it doesn't look like you're in fear. So you have to have both.
So you've represented cases like this?
Yes, I've had lots of self-defense cases.
Really? So
Yes.
so it's common for people to brandish their firearm and then get arrested.
Yes, it happens most of the time.
Thank you. Fucking TikTok.
Yeah.
Let's hear that again. It's common.
It happens most of the time. I'd say 90% of the, especially local law enforcement here. I deal with the local sheriff's department, the local police departments, or whatever. A lot of them they're just not Second Amendment friendly. I mean, I know a lot of the guys on the street. I work with them. Yeah, they're not Second Amendment friendly, especially from the brass at the top. So if a firearm is used in a case, personally, I would say probably there's a 90% chance that person's going to get arrested. there's a 90% chance that the state attorney's office, because I know for a fact, at least in my personal opinion, based on my cases, the state attorney's office is not pro Second Amendment. They're fine with charging people with gun stuff all the time. And so what I always tell people is if you pull your gun, you should be prepared to go to jail because there is a high likelihood that you're going to jail.
Wait a minute. So if you pull your gun, you should be prepared to go to jail.
Yes.
If you use it too?
Yes. Well, probably more so if you use it because now you've used it.
You mean you just can't smoke somebody and show your concealed weapons permit and go home?
No.
Okay.
No. I mean, there's going to be a really small percentage of cases where it's clear self-defense. You know, it could. I've never seen a scenario, but let's say
case dependent. Everything
is case dependent. But let's say you have a clear case of self-defense. 3 guys are laying on the ground, shot. They've all got ski masks, their own guns. There's a surveillance camera that shows you were just walking down the street. They pointed a gun at you and you shot them in self-defense. Okay, that's like less than 5% of the cases.
Okay,
most cases, there's either no other witnesses. Mm-hmm. There's no independent thing like a surveillance camera. You always have the victim that says, I didn't do nothing. He just shot me for no reason. You have the shooter saying he was attacking me, so I shot him in self-defense. And the cops usually have to make a judgment call at the scene. And the judgment call is 90% of the time, in my experience, I've been doing this for 23 or 24 years now locally. In my experience, 90% of the time, you're going to go to jail. Now,
okay.
I can lots of times get the state attorney's office to not file the charges. So you can intercept the case between the cop and the state attorney, and you can talk to the state attorney and say, look, I know they arrested him at the scene, but here's case law that I found that supports my guy, or here's a witness that the cops didn't know about, or whatever.
And
so sometimes you can do that. So
like how much is it? So let's say I am now in jail for brandishing my firearm, and I call you. How much does that cost?
Well,
how much is Jeff Young retainer?
So there's other things. It's not just Jeff Young retainer. Obviously, you get arrested, you got to post bail. So you're gonna have to come up with, usually, let's say the bail is usually set at $5,000 to $10,000. If you have no criminal history and ties to community, you either got to come up with that or you got to give 10% to the bondsman. As far as the attorney goes, it always depends on the case. Like there's never really set fees per whatever the charge is. So it depends on what the charge is. Is it a misdemeanor improper exhibition? That's probably going to run you around $3,500 to $5,000. Is it an aggravated assault where nobody was shot? That's probably going to run you around $7,500 to $10,000. Did you shoot somebody? Now you're looking at $25,000 to $30,000. If you killed somebody, you're looking at $50,000 to $100,000, depending on how strong the evidence is.
So 90% of the time, you have found in cases where people are drawing their firearms in fear, they end up getting arrested.
Yes.
That's fact. Happens all the time here, or 90% of the cases you have found.
Yes. Well, obviously, if they come to me, they've been arrested. Yeah. Now, full disclosure, I don't have all the stats. Let's say the sheriff's department. Like I don't know every case that they get called out on. They may say, well, he doesn't know that we dropped 30 cases last month where they pulled guns, and he's only seen the ones that hire him. That's true. That's a fair statement, but I feel confident in my knowledge and how long I've been doing this based on what I've seen and who I've talked to, all the other attorneys that I know, all the cases I see that come through court, that basically if you pull a gun, there's a high likelihood you're going to go to jail. And you can ask anybody that. You can ask Florida Carry Inc. You can ask the guys at the NRA or the USCCA, the insurance companies. They'll all tell you that any trainers will tell you if you've ever taken a concealed carry class or whatever, they'll all tell you the same thing. If you pull out your gun, you need to be prepared to be arrested, go to jail, and have to hire an attorney.
Ha! TikTok. Fuckers.
What if you pull out your gun, what percentage of those cases are being tried or are getting, the prosecutors are charging you with that?
So again, I can only speak for my cases. I don't know all the stats for all the other attorneys, but when a case comes to me, usually if a person's arrested, they're most likely going to get charged. There is a small percentage of cases where I've had somebody get arrested and then the state attorney's office dropped it. For example, I don't know if you guys remember, but the very first case I did to this, which kind of put me on the map, I'm not going to say the kid's name, but there was a kid locally that was riding a motorcycle, and a guy followed him on the road, was trying to run him off the road, followed him into the gas station. He got off his motorcycle. The guy got out of his car, rushed him immediately, threw him on the ground, and the kid pulled out his gun and shot the guy. He immediately went inside, called 911, stayed at the scene, put the gun down. Cop showed up, gave himself up. He didn't make any statements, which is what I always tell people not to do. And they got the surveillance video, which showed all of this. Like, these facts were not in dispute. They arrested the kid for aggravated assault with a deadly weapon, causing bodily injury because he shot the guy. Even though it was on surveillance video, the guy clearly attacked him first. He was arrested, had to bail out, had to hire me. He didn't have a lot of money, but the local gun community got together and took up a collection or whatever, and they were able to pay my fee. I was able to talk to the prosecutors and get them to drop it. We had a meeting. I went in, talked to the higher ups. We went over the surveillance video. I went through exactly what happened. They ended up dropping the charges, and so he ended up not getting actually formally charged. He was able to get that sealed and expunged, et cetera, et cetera. And then, the case went on from there. So that does happen in some cases. What was lucky in that case was there was a surveillance video. Had there not been a surveillance video, the guy who got shot would have said, all I did was get out of the car and I wanted to go up and say, hey man, how are you doing tonight? And the dude just shot me for no reason, which is basically what the guy said. The guy said, I didn't do nothing. I just pulled into the gas station. I walked up to him. All I wanted to do was say, hey, why are you driving so crazy? And he just shot me for no reason. That was his statement to the police. My guy didn't make a statement because that's what I tell people to do, is not make a statement. So had there not been a video, it would have just been the guy's word against my guy not saying nothing, and they would have filed it.
Didn't you find extra video, if I remember correctly? Like, there was extra, like the video that was initially found wasn't the whole story. Like, it was.
No, it was.
Like, there wasn't the guy fucking chasing him or some shit.
So that is what I was able to provide them afterwards. There wasn't video of the chasing earlier on, but I basically went to the state attorney's office, said my client's version of events is this, that he was chasing him as well. But the actual surveillance video of the guy attacking my client, out of the blue, and my client defending himself, the cops had that before they made their decision, and they still arrested him.
Whoa. So they had so local law enforcement had video of, if I remember, he was kind of a big guy.
Yeah.
He came up and was forceful. The kid walked away I feel threatened, leave me alone, kept coming. And they still charged him.
Yeah. That's what I'm saying. It doesn't matter how in my opinion and experience, it doesn't matter how pro self-defense the situation is. They like to arrest people in those situations. They don't law enforcement has a tough job. They don't like guns in their community. And so any chance they can get to arrest somebody for a gun charge, I personally believe that they will. Unfortunately, there's also a large percentage of the people who get arrested who should be arrested for what they're doing with their guns. It's kind of a weird situation. So for example, they get pulled over and maybe they didn't have a concealed, you don't need one now, but back in the day when you needed a permit, they would put their gun under the seat of their car. Normally not a big deal. You're not allowed to do that if you didn't have a permit. But what would happen is they'd arrest them, they'd search their car, and then they'd find a kilo of cocaine or a bag of marijuana or a bunch of rolling papers or whatever because they were selling drugs. And so you end up getting the gun charge thrown in with other charges. So you could go to trial and say, look, that's a bullshit gun charge, but they come to you and say, well, your guy can either take trafficking in 15 years or we'll give him, a year county jail and he'll have to plead to the gun charge. So you end up kind of negotiating that kind of stuff out. So they look at it as everybody should go to jail for guns because they don't like guns on the street. Unfortunately, it sucks up a lot of people who probably were legitimately in self-defense.
So have you become more pro 2A or stayed the same or less pro 2A since you started becoming the gun lawyer?
I guess I would say more. So when I first started about, I want to say 10 to 12 years ago, I didn't own a firearm. It wasn't that I was against them. It's just I never owned one, never shot one, didn't really have any desire to or whatever. And then I actually had a really good friend. I call him my cousin. His name, Mike Young, Skinny. He used to own
Skinny.
Yep, he used to own Young Guns and Safety. And so I went in there one day. He kind of got me into it, gave me my class, sold me my first gun, and he was like, look, nobody really does Second Amendment law around here because everybody's always trying to find a Second Amendment lawyer, so you should learn how to do it. And so I did all the research, started going to class, taking the CLEs and the classes and stuff, and I started doing it. And I just wasn't in the community at that time. So again, I didn't own a gun or whatever, so I wasn't familiar with all the people that are in the gun community. And I had been a prosecutor, but I just didn't get a lot of gun cases. When I was a prosecutor, they were mostly drug cases and domestic violence and things of that nature. So I hadn't really been delved into that community. When I got deep into that community and started representing these people and seeing them and going to the dinners and being on the Facebook groups and hanging out at the shops and doing gun trusts for people and stuff, I really did start to see kind of the persecution that went on with them, the things that they would suffer, like if they got charged with something, or the hoops they had to jump through to get their concealed carry permit or something. I just started to take notice of politicians and things they would say and what the laws said about guns and not guns. And I realized that pretty much all of it is unconstitutional. Like I'm a Second Amendment absolutist. There's a period at the end of it. It's not shall not be infringed, comma, unless Nancy Pelosi thinks I shouldn't have a gun, comma, unless some local judge thinks I shouldn't have a gun, comma, et cetera, et cetera. It's a shall not be infringed, period. So I'm one of those Second Amendment extremists who thinks all gun laws are basically unconstitutional. You shouldn't have to pay $200 to get a stamp to have a suppressor or a full auto. You should be able to open carry. I personally wouldn't open carry because
machine guns for everybody.
Tactically, it's not smart, right? Everybody should have a machine gun. I have no problem with that at all.
Absolutely.
But there shouldn't be any gun laws, quite frankly, as far as I'm concerned, unless they want to change the Second Amendment and add those commas in there. Until then, my opinion is they're all legal. So I've definitely become really extreme when it comes to the Second Amendment. I love fighting with the Department of Agriculture and the FDLE and filing lawsuits against those people. I work closely with the guys at Florida Carry Inc. I file motions all the time to get cases thrown out. So I really love it.
Can I ask? I've always wanted. All these ideas are like going around in my head. I'm like, oh my God, we can ask him all these questions that come up every fucking day. The holster that you can see it in the car, that it like people,
The magnet
stuff or like something like that, right?
Yeah. Is that legal?
No.
Can you say that again?
So here's the deal. Open carry is illegal in Florida. That includes a handgun in your car. I'll say that technically open carrying of a rifle in your car is still illegal. You could theoretically have the shotgun rack on the back of your car and have it be legal. Although I have run into prosecutors who disagree with me on that. So even though I believe it's legal, again, prepared to be harassed and possibly charged. But for sure, it's handguns, open carry is illegal. So if you're driving in your car and you take your firearm and you just set it on your passenger seat, open carry, that's an open carry charge. It's a criminal charge in Florida. You'll get charged with open carry. If you leave it on the seat and take a towel and put it over top of it, that's legal because now it's concealed. So the magnets work the same way. If you put a magnet or a holster and you just stick it on there, there's nothing covering it, so it's open carry. So if a cop walks up to the window because you're speeding and can look through the window and see your gun attached to a magnet, it's open carry because it's visible to him.
Then how the fuck are those people selling those things?
So because it's illegal in open carry. So okay. you can be in other states where it's legal. Open carry is legal, and you can have those things. Florida does not have open carry.
The magnet's not illegal. Sticking your gun to it in your car is illegal.
Correct. And you could do that. And once again, you could take the towel and put it over top of your gun on the magnet, and it's perfectly legal because now it's concealed. That towel falls off of there, it's an open carry.
Have you represented anybody who has gotten popped for having the magnet?
No, I have not represented anybody who's gotten popped for the magnet. I have represented people for the holster dispute with the retention holsters. So, for example, in order to carry it in your car without a concealed carry permit, again, before the law, so let's say before the concealed carry permit law changed, to carry a gun in your car without a concealed carry permit, it had to be securely encased or not readily accessible. So it had to basically be in a locked container, your glove compartment, your center console. Or you could put it in a holster with a snap on it. So take the scenario I said before, where the guy just took a gun and put it under his seat. If he put that gun in a holster that has a snap on the back, puts it under his seat, that's legal because the holster has a snap on it. You take a retention holster that doesn't have the snap on the back, but it's got, the retention in the middle, and you could shake those things all day long and nothing comes out. That's illegal because it doesn't have a snap on it. The statute specifically says, or in a holster with a snap on it. So if you put it in any other holster that doesn't have a snap on the back, it's illegal. So I have had people get picked up with the gun shoved under here or shoved down here in the middle, and they're like, hey, it was securely encased because you can't get those things out of these holsters, but it didn't have a snap on it. And the case law is quite clear. As stupid as it sounds, it's got to have a snap on it. So I have had people get popped with those.
So what's the correct, like, can you have a firearm in your car?
Yes.
You mean, because now the law is different with concealed carry.
So the only thing that changed with the concealed carry law is now you don't have to have the license. All the other laws are the same as it relates to firearms. Where you can carry, when you can carry, open carry, how you can carry, like nothing else about the law changed. All it says is that if you were eligible to get a permit, you don't have to pay the $200 to the government or whatever to get your permit. So all the same laws apply. So let's say you have a concealed carry permit, you can conceal it in your body. So you can take a firearm, you can put it on the seat and throw a towel over it, and it's perfectly legal. That is the same now whether you have a license or you don't have a license. If you don't have a license and you're not technically eligible to have a license, then you still have to carry it securely encased or in a locked holster.
Do you recommend still getting a concealed weapons permit?
Wait, so if I don't have a permit, I can't put a gun concealed in my car?
Yes, if you're eligible for a permit.
If I'm eligible for a permit.
Right.
So if I can have a permit but don't have one, I can have a gun in my car concealed.
Correct. So I'm trying not to get into the weeds because I don't want to bore everybody, but there's basically four categories of gun people. People who are prohibited, convicted felons, domestic battery, they can't have a firearm at all. So it's illegal for them to have a firearm under any circumstances. Then you've got people who can possess a firearm, but they can't conceal carry a firearm. Then you have people that can legally conceal carry a firearm, but just don't have a permit. And then you have the people who can carry who don't have a permit who have a permit.
Who can't conceal a firearm?
So let's say you received a withhold of adjudication on a felony. So in Florida, you could either be convicted of a felony, which means it's on your record forever and you're a prohibited person and can't possess a firearm.
Correct.
We also have something called a withhold of adjudication, which means you go on probation, you pay your fines and stuff, but you don't get a conviction. So there's a conviction, not guilty, and we have this thing in the middle called a withhold. With a withhold, it does not affect your Second Amendment rights. You are permitted to possess a firearm. However, in Florida, you are not eligible for a concealed carry permit until 3 years have passed since you got off probation with your withhold. So during that 3-year period, you're not a prohibited person. You're allowed to possess a firearm, but you're not eligible for a concealed carry permit because you got the withhold, so you can't carry without a permit. So there's a small group of people who have a window in their lives where they wouldn't be able to conceal carry. Also, 18 to 21-year-olds. Because 21-year-old, if you're 18, 19, or 20, it's illegal. You're not eligible for a concealed carry permit.
Right.
So you can't conceal carry. But you can possess a handgun at 18, 19, or 20. You just can't conceal it. So those people can carry the firearm in their car if it's securely encased.
With the clippy thing.
With a inside a container or a snap holster or otherwise not readily accessible. Yeah. So there's a small category of people who are allowed to possess a gun but can't conceal it. For those people, they can still carry in their car as long as they securely encase it or not otherwise accessible.
So I imagine you get probably pretty busy at times. Like, do a lot of people get in trouble?
So it can be confusing for a lot of people because, again, I'm explaining it to you guys and you're like, wait, why can't you carry them? Why can't you carry? So it gets confusing for a lot of people out there because the laws are confusing. What they should just do is repeal them all. So in other words, we had the concealed carry law that said you had to have a permit. Then they wanted to go to permitless carry. And so instead of just passing a law that repealed the requirement for a permit, they left the permit law in there and then added another law that says, oh, but you don't have to get the permit. Same thing with open carry. They want to add an open carry law. All you'd have to do is repeal the law that says open carry is illegal. So once again, politicians, instead of taking laws away, they always add to them. And every time they add to a law, it just confuses the shit out of everybody. So I get a percentage of of clients that thought they were doing what was legal, and then it turned out it wasn't because they just didn't know the law because it's confusing.
What about the home gun range thing? That's a hotly contested question. Like, how is it legal to have a range in your house in Florida? Like, what do you need to
Like
do
in
to
your
build-
house?
I don't know. Like, what do you need to do to build your own range?
There's
What are the requirements?
There is no requirement.
There's no
So
requirement.
no, that's a misnomer. A lot of people think there's a statute that says if you want to have a range, you have to build a berm that's X number of feet. It has to be made with tires versus
Yeah,
no,
like 70
there is
yards
nothing.
from the road.
No, there is no specific rules about having it on your property.
So I can build a range in my backyard, or my
Yes.
So I can let me maybe make it my garage. That's kind of big.
Yes. The only requirement is that you not be negligent with your firearm. So, in other words, if you build a little berm and there's no requirement, but let's say it's obviously it's smart. You build a berm in your backyard and you shoot into it. It's perfectly legal. If you shoot without a berm at a target on your wood fence and the bullet goes through your wood fence and shoots your neighbor, that's not legal. So it's not necessarily about
Remember that?
yeah, it's not a construction law. It's basically a negligence law with how you use your firearm on your own property.
What happened to that when the guy did that guy ever get charged?
No, because they couldn't prove who the shooter was.
Really?
So you go over there and there's 4 people that live in the house and nobody confesses to being the one who pulls the trigger. There's nothing they can do about it.
Do you guys know about that?
No, so what is this?
So back in the day, allegedly somebody was shooting a Ruger 1022 in his backyard range, and the target was on the guy's fence. So the guy's just plinking there, and there was a neighbor watering his grass, the neighbor's grass, and I think the neighbor was kind of like a hippie. So he's sitting there watering his grass, and allegedly somebody shot a 1022, went through the fence, hit the guy in the back of the head, and he died.
Oh,
And the sad thing is if I remember correctly, the guy was out there for like 8 hours on a Saturday or something, and people just walking by, and there's this dead guy in the grass with a hose going off.
Yeah, it was a
Was it? Am I right? There's
no.
that-
I don't remember the hose going off stuff, but
like, well, he was watering his grass.
It could be.
It did-
But the,
it didn't stop.
but yes, that was the facts. Is basically they were shooting their 22 in the backyard at a target on the wood fence, and the bullet went through the fence and killed somebody next door. So you can't basically be negligent.
But there's nothing illegal
With the firearm.
about having a range, even next to another house. Like, you could be shooting. You're legally allowed to do so.
I actually have a case right now on this, so that's why I'm pulling up the motion that I filed so I can find the statute for everybody.
Wait, you have a case like that?
Yeah, I've currently got one right now where, you've all heard the phrase yard pop.
No.
You go outside and you shoot a bullet into the ground outside your house. I got somebody who did that, and they charged him with discharging firearm in public or on a residential property. So I have a pending motion to dismiss on that. So I just want to read you. I like to quote statutes as a lawyer. So Florida statute 790.15, discharging firearm in public or on residential property. Except as provided in subsection 2 or subsection 3, any person who knowingly discharges a firearm in any public place or on the right-of-way of any paved public road, highway, or street, or who knowingly discharges any firearm over the right-of-way of any paved public road, highway, or street, or over any occupied premises, or who recklessly or negligently discharges a firearm outdoors on any property used primarily as a site of a dwelling or zone exclusionary for residential commits a misdemeanor of the first degree. So there's 2 sections. One is public. So you can never just discharge your firearm in public. If you're in a public park or on a highway or whatever, you can't shoot your gun.
You can't shoot the gun in the dog park.
Correct.
Okay.
However,
Dean.
the important one is, or who recklessly or negligently discharges a firearm outdoors on any property used primarily as the site of a dwelling or zone exclusively for residential use. So that's where your house range comes in.
So you can't be reckless.
Right. The only requirement is you can't recklessly or negligently discharge the firearm. So that's where the issue comes in, where it's negligent to shoot a bullet at a wood fence thinking it's going to stop it. If you shoot directly into your ground, the argument is there's no negligence or recklessness there because the bullet's going directly in the ground. So once again, it all comes down to a factual thing. I get these cases all the time. What happens is people live out in the country. They build a range on their property. Everything goes great. And then one of these damn developers comes in and buys up all the land around their property and slaps up 1,500 homes or whatever.
Yeah.
And now all of a sudden everybody in the fancy subdivision is like, why do I keep hearing guns go off? Why do I keep hearing bullets go off? And all of a sudden your quiet range that didn't affect anybody is they're angry about it. And so all of a sudden they start saying things, and I've had this, that they make it up like, oh, I heard a bullet whiz by my house. My kids were playing in the backyard the other day, and I'm certain a bullet landed in the grass. And they just keep calling the cops, and the cops keep going to the person's house and saying, hey, we need to make sure you're not recklessly or negligently discharging your firearms. And then it just becomes a hassle, and some people either take down their range or they move, or they do what I tell them to do, which is read statute 730.51. It says I can shoot my gun here and have a good day. But I've had developers sue people to try and get an injunction. They've brought in, all these forensic people to analyze where a bullet might come from the house, and they've taken, satellite photos or whatever. Like, they can get crazy about that kind of stuff.
Really?
Yeah. But the statute does not require any specifics for building a range. There's no height requirement, no thickness requirement. Obviously, everybody should use smart common sense, but there's no requirement of the law.
In the statute you just wrote, you can't shoot towards the road.
Right, you can't shoot over premises because if you shoot over a home, obviously the bullet's not going to come down.
Shoot towards the right of way, which is the road.
Right, it's all the public stuff. So you can't do it in any public place or on the right of way of any paved public road, highway, or street, or discharge it over the right of way of any paved public home, highway, street, or over any occupied premises. Because again, if you're shooting over the premises, it's almost per se reckless and negligent because your bullet's got to come down somewhere.
So, Dean, we're on. Go get your buddy with the excavator.
Hell yeah, that's what I'm
Let's
thinking.
build a fucking range.
That's what I'm thinking.
I've got 7 acres out east.
We just got the green light.
Green light. What about the pot thing?
What about it?
So we, as FFLs, if somebody comes in stinking like marijuana, we choose not to sell them firearms. What's the? Does that come up a lot in your social milieu?
You mean if they're using it, or they just have their medical marijuana card? Yeah,
using it.
Well, right now, as you know, because of the questions that are on the 4473, marijuana is still illegal in the federal, as far as the federal government's concerned. It's still a class 1 or whatever it is.
Why didn't Joe Biden make it legal? Didn't he say it was going to?
Every president does. Trump said he was going to make it legal. Like, they all say that, and for whatever reason, it doesn't go anywhere. So because it's a Schedule 1 narcotic on the federal government's registry, it doesn't matter what your state says. So your state can approve medical marijuana. Your state can approve recreational marijuana. It doesn't matter. It's still a prohibited drug under the federal government. Therefore, if you are using marijuana, either with a prescription or not a prescription, you are a prohibited person as far as the federal government is concerned, and prohibited people can't purchase or possess firearms. So if you have a medical marijuana card, you cannot possess a firearm, even if you're not using it. And the reason why I say that is because, as you know, as the shop owner, they basically tell you that there's a presumption that if the person has a medical marijuana card, that they're using the marijuana, and therefore you have to deny their purchase. So there's a presumption that if you have a card, you're smoking a marijuana, whether you're actually have your prescription current or not, and therefore you can't have a gun.
Whoa.
It's weird. Yeah, you can't have a gun. Going back to the last topic, though, I don't want to move off of it because I don't want to have TikTok jump all over me for bad advice. So you were talking about target shooting. So like a recreational target shooting, maybe build a range on your property. There is a small caveat to that. So
subsection 4,
any person who recreationally discharges a firearm outdoors, including target shooting, in an area that the person knows or reasonably should know is primarily residential in nature and that has a residential density of 1 or more dwelling units per acre, commits a misdemeanor of the first degree. So you will hear people talk about an acre. You got to have an acre of property. That's true if you're going to recreationally target shoot. So if you're going to go outside and shoot into the ground as like a yard pop, you don't have to have any requirements whatsoever other than recklessly and negligently. If you want to actually build a range and recreationally target shoot, there are no requirements for the range. Berm size, whatever doesn't exist, but you have to have at least an acre of your house per dwelling or whatever. So if you got something less than an acre, you live in Lakewood Ranch and you're in a cul-de-sac with everybody stacked up on top of you, you can't put a target in the back of your house. You could go shoot into the grass or shoot into your pool or whatever, and it'd be perfectly fine if you're just doing it for fun. But if you want to actually have recreational target shooting, you have to have at least an acre of property.
Okay, so all right, Dean, we're good. What about like building one in my garage?
Yeah, I mean, there's nothing about indoor stuff. I mean, you may have, I don't know, building codes. So, there may be each individual county may have certain building codes for what you can put in your home or whatever. But outside of a county building code, there's no state statute that says you can't have an indoor gun range at your house.
Fuck yeah.
Because it can't go, again, that would be the safest way to do it, because then you never have to worry about it going off the property.
Or remodel my garage.
Yeah, no, certainly people should do that. But back to the marijuana thing. So yeah, you can't have a card and purchase or possess a gun. I mean, look, Hunter Biden just got in trouble for that, because that was his whole big thing is they were trying to claim he wasn't currently using, despite all the stuff on his laptop that said he was. But setting that aside, the issue is he wasn't currently using when he lied on the form, so you can mark whatever you want. But that's not how it works. If you're using it legally, as far as your state goes or not, you can't have a firearm.
What, did he had a marijuana card or something?
No, he was just using marijuana, and he was also using cocaine and stuff like that. So, but the argument they were trying to make is that he wasn't currently using it, because the question is like, are you
like at that time
an addict or a currently user? Right? They were like, oh, he hadn't used it for a couple days or whatever. So that was kind of their defense on that.
Oh, really? So you can. I get that. What about the whole trigger thing in Florida? Like, are you allowed to have a FRT trigger or a binary? What is it? Binary.
Like the binary triggers?
Yeah.
I mean, I'm gonna say no, and most lawyers will tell you no, because the way they wrote the bump stock statute.
Hold on. So you're not, according to Florida law, it is your opinion that you're not legally allowed to have a binary type trigger in Florida.
Correct.
Why?
Because when they passed the bump stock ban here in Florida, it's part of that,
right?
Yeah, it was part of the Marjorie Stoneman Douglas Act, which was one of the worst piece of anti-Second Amendment legislations in history here in the Gunshine State, for all the hypocrisy there.
People were pissed.
Right. So they passed a bump stock ban, but they didn't just say bump stock. They basically made it this broad definition that included essentially anything that makes your gun fire faster than like a normal trigger pull.
They said accelerates the rate of fire.
Correct. So when you have a binary trigger, it does that. When you have the FRTs, or what are they? Rapid trigger. What's that stand for?
Fast reset.
Fast reset.
Forced reset.
Right. Forced reset. That's right. Where you try to pull the trigger, it does it on its own. Right. So those are specifically designed to make the gun fire faster than its normal rate of fire. Therefore, in my opinion, and every other lawyer I've talked to, again, the guys at Florida Carry, everywhere else, they'll tell you that in their opinion, anything that does that falls under that definition of bump stock and is therefore going to be illegal. So I have been telling people for certain ever since they passed that law not to have binary triggers or force reset triggers or certainly bump stocks or anything along those lines.
Did you buy a bump stock from me back in the day?
I did not. I have some stabilization braces from you that I took off during that period, and then now that's technically back, so it's kind of like a back and forth on that. So I do have a couple of stabilization braces.
So the bump stock law from the Marjorie Stoneman Douglas Act hasn't been repealed.
Correct. That's still the Florida law.
It's still on the books.
Yes. So I know the federal ban,
despite TikTok.
Well, right, and I know the federal ban that Trump, of all people, put into place was overturned. The Supreme Court recently overturned the federal ban. The problem is state of Florida passed a specific statute making it illegal in the state of Florida. So the federal law was thrown out, but the state law is still in place. So even though that case law came out that overruled the bump stock ban in the state of Florida, bump stocks are still illegal, and any other rapid firing device or whatever is still technically illegal in Florida, so you can't have one.
Have you ever had to represent someone with one of those triggers?
No.
Oh, wow.
No, because number one, you're never going to find out. Like they didn't give them the right to come in and obviously kick your door in and take all your guns and see if you had one of those force reset triggers. They would only find out if you used it for some reason. If you used it in a drive-by shooting or something, they caught you and they found a bump stock ban or an FRT trigger on there. That could be an additional charge that they would just add on to your murder charge. So nobody would really care about it. But nobody is like, I haven't seen any ATF agents walking up and down ranges and randomly asking people, can I see your trigger to see if it's a force reset or whatever. So it's a matter of being able to find out whether somebody has it or not.
Like, speaking of which, does law enforcement or the range safety officer have the right to ask you for your tax stamp at the range?
So the range safety officers can do whatever they want because it's a private business, so they can have whatever rules that they want. If their rules are you want to come in here and shoot, you get to see your tax stamp, then they can do that. The ATF, like the cops, local law enforcement can't do that. I know that. I believe that anyway because it doesn't fall under their purview to check that.
So the local, go ahead.
I'm not 100% certain on that. So before I get into all that stuff, I don't know right off the top of my head whether they would have the right to do that or not. Theoretically, the ATF has the right to ask you to produce your tax stamp if you're in possession of a tax stamp item.
Yeah, but law enforcement.
I honestly don't know the answer to that.
Okay.
I can research and get back to you, but off the top of my head, I do not know if a deputy is at the range and he walks down and says, I want to see your tax stamp. My gut feeling is no, because again, it's a federal thing. It's not a local thing. So I don't think that they would, but I wouldn't, before anybody jumps on me, I wouldn't 100% quote me on that.
So the RSO can ask you for the tax stamp because they have the ability to kick you out of the range.
Correct, right.
So you don't have to show it to them, but you have to get out of the range.
Correct. It's like anything else. Yeah, you could say,
It's like
F you, I don't want to show it, but they'll kick you out.
It's like when somebody brings an SBR in here. It's the same thing.
Right. Every business, it's the same thing. No shoes, no shirt, no service. You can have your own rules at your own place. So that if the range's rule is that anybody who comes in here with a NFA item must show us their stamp, then that's the range rule, and you can either shoot there or go somewhere else.
So should you talk to the police if you get arrested? What should you do?
No. Like, my advice is to never talk to the cops if you're getting arrested, because nothing you say is going to help you at that time. Especially, let's say it's a shooting. You should never talk to the cops under any circumstances, but especially in a shooting, because your mind's not going to be thinking straight. Your adrenaline's going to be pumping. Everything happens so fast, you're not going to have time to decompress and figure out exactly what happened. So any little thing that you get wrong, they're going to use against you. So if you say, hey, the guy was 5 feet away from me, and they measure it and it turns out he was 8 feet. Oh, well, you're lying. Why did you tell us he was 5 feet when he was actually only 8 feet away? So, like, any little thing like that can come back to bite you in the ass, especially if they're looking to arrest you for something. So I never cooperate with police.
Are you breaking the law often?
No. I just don't talk to them. Like, there's no reason to talk to them. There's no reason to give them permission to search your car. There's no reason to give them permission to search their house. If they've got a warrant, you have to comply with the warrant and let them in. But when they ask you, hey, can I search your car? Tell them no. They don't have any reason to search your car. If you've been involved in a shooting and they want to question you, usually a couple different things. Number one, if you have insurance, and I always recommend that people, if they can afford it, get the carry insurance, whether it's through USCCA or US Law Shield or any other ones out there. If you have the insurance, then you call the number on the back of the insurance card. They'll call a lawyer. I'm actually listed as a local lawyer for both of those companies. So they'll call me at 2 o'clock in the morning, and then I'll tell the cop, hey, my guy's not making a statement. Stop talking to him. They'll be the ones that can also set you up. If you get arrested, they'll pay for the bondsman. They'll pay for your lawyer for you, so you don't have to pay that $50,000 or $100,000 fee that we're talking about. The insurance will cover it. So you should have the insurance if
so
you're
you
going to carry.
that carry, that thing we see, like the insurance from CCA or whoever, or National Shield Law or whatever, you think that's a good thing?
Yes. Whether it's USCCA or US Law Shield, I know the NRA has their own. If you can afford it, do some shopping around, just like car insurance, house insurance, whatever. Do some shopping around. But if you can afford it, you should definitely get
and they'll pay your bail.
Insurance. Correct. They'll pay your bail. They'll pay your attorney. They'll pay your private investigator. Now, do your research, because a lot of them have levels, gold level, platinum level, whatever, which will deal with the type of coverage that you get. Again, it's just like your car and insurance or your house insurance. So do your research, find out which one fits best for you, and that will affect your premium amount and everything else. But if you can afford that, you should have that. And you call the number on the back of it, and you just tell them, I'm not going to make a statement until I call the number on the back of it, and I want to talk to them, and I want to talk to a lawyer. That's perfectly reasonable. You don't have to be rude about it. Don't say F you, I'm not saying anything. Don't say the Manslaughter gun lawyer told me to tell you to fuck off, because that's not what I'm telling you to do. Just tell them you don't feel comfortable making a statement. You want to talk to your lawyer first. They'll have to respect that, and they'll just be like, okay, fine. They may still arrest you, but they may arrest you anyway, and you're not going to talk yourself out of it, basically. So I never advise anybody talk to police. If you shoot somebody, call 911 if you can. Tell 911 that you were just attacked and you had to shoot somebody in self-defense. This is our location. Send an ambulance, and that's basically it. If the operator starts asking you questions, you don't have to answer those questions. Just say, I don't feel comfortable answering those. I'm too nervous. Just send the ambulance. Send the ambulance. When the cops get there, tell them the same thing. I don't want to talk to anybody until I talk to a lawyer. Most of them will respect it. They have to respect it legally, but most of them will be understanding and say, okay, fine, I understand you don't want to talk to anybody. And just don't talk to anybody. If you get arrested, then so be it. Like I said, you're most likely going to get arrested anyway. And if you talk to them, you make it a lot harder for your attorney to help you out down the road, because now we're stuck with what your statement is. And I'm not saying you should certainly never lie to the police. The first thing you should do is never lie to the police. Either don't make a statement or tell the truth, because if you purposely lie, I've had people do that. Oh, I didn't pull out a gun at all. I never pulled my gun. I don't know what you're talking about. But then the person can describe exactly what color the gun is, if you have a sight on it or whatever, and then they find the gun like sitting in your passenger seat. But now you've made a statement on the record that says, I never pulled my gun. So when I go to the prosecutor and say, hey, he actually pulled his gun in self-defense, they're going to say, well, why didn't he tell that to the cops? Instead, he said that he never pulled a gun. So you're not going to be able to talk yourself out of it. So just don't make any statements. Call the number on the back of the card. If you don't have a number on the back of the card, just tell them you want to you'll be happy to make a statement, but you want to do it when you're nice and calm and you've had a chance to talk to a lawyer. And if they arrest you, you just deal with that. If they don't arrest you and send you home, then you can call the lawyer, and then the lawyer can sometimes set up an appointment. I've done that before. I've set up the appointment. I've gone with the client to the police department and then help them with their answering questions, and I've been there to help them with it. So there's ways to do that as well. But you should never talk to cops if you're being investigated for crime.
Something I wanted to ask you about the brandishing the firearm thing, or that little discussion. In these cases where you're representing people for whatever, road rage, etc., does law enforcement take your firearm?
Yes. They're always going to take your firearm. Even if they don't arrest you, they'll take your firearm because it's evidence in the case. So they will confiscate your firearm. They'll put it into property. They may do things to it. If they need to run ballistic tests on it or whatever, they'll run ballistic tests on it, and it will sit in property basically until your case is over.
So you brandish your fire. So guys coming after you with a knife, you pull your firearm, chase the guy. Cops come, you get arrested, you lose your staccato.
Yeah, they're
Every time.
definitely going to take that firearm. Even if you're not arrested, they're still going to take the firearm. Like, they're always going to take the firearm if it was involved in a shooting. They do the same thing with law enforcement. If law enforcement uses a firearm in shooting, they take the gun from the guy. So if you use your firearm, especially if somebody's shot, they're 100% going to take it. If somebody's not shot, they're 99.9% going to take it, because there's no reason not to, because the case is still under investigation. What's even worse is, what usually happens if they think you're guilty, like if they think that you did an ag assault and weren't justified in pulling your gun, they'll take that gun. Then they'll go fill out a petition for a risk protection order, which is the red flag thing. They'll get an order from a judge, and then they'll take all your guns, because you can't have any firearms while you have an RPO.
Jesus Christ.
So I get people that get arrested, and while they're in jail waiting for bail, they get served with an order from a judge that says, we've confiscated all your firearms.
So do you see red flag laws stuff a lot?
All the time.
All the time.
The sheriffs in Florida
Isn't that kind of
love their red flag law.
Isn't it kind of anti-Second Amendment?
It's 100% anti-Second Amendment, because they're taking away your firearms before you even get a hearing in front of a judge. All it takes is
How's that fucking legal?
So a law enforcement officer goes and fills out an affidavit that says, I think this person has endangered himself or others, and he has these many guns. They send that to the judge. The judge reads it. The judge signs an order, immediately confiscating your firearms. They then go to your house, serve you with that order, and tell you you have to give me all your firearms. Or sometimes they'll let you transfer them to a third-party person, but most of the time they want to take all the firearms. Then 2 weeks later, you get your hearing in front of a judge where you get to go in front of a judge and say, hey, you shouldn't have taken my firearms 2 weeks ago because I didn't commit this ag assault. The cops are wrong. So they do it all on the backside.
Really?
So you will, and they do it every case that I've ever had where somebody was charged with a gun crime. There's always been a risk protection order that comes along with
fuck.
it. It's like it's
automatic?
automatically. Like I think they have a red flag in their computer system over there that's like gun charge, RPO, gun charge, RPO, and they get them all the time. And the judges always sign them because they don't want to be the judge that doesn't sign it.
Didn't sign it.
And then this person goes out and murders a whole bunch of people at a shopping mall, and all of a sudden the judge is out of a job.
Like the Pulse guy.
Right. And they figure, well, what's 2 weeks? What's the big deal? You know, they can go without their gun for 2 weeks. Now, I think the judges legitimately believe, I mean, I'm not disparaging our local judges, but what I'm saying is I think that there's a tendency to sign those things more than there is to not sign those things. And I've only seen the ones that get signed. Again, I haven't seen all the statistics. Maybe there's some that come in that don't get signed, but it's been my experience that those risk protection orders generally get signed 90-something% of the time. Now, you can win them at the hearing. I've won risk protection orders when you come into the hearing 2 weeks later.
How many have you lost?
But most of them get signed. Well, I've never actually lost a hearing. So it depends on your definition of the word lost. Whenever I've actually had a contested hearing, witnesses come in, et cetera, I've always won those. But there are lots of times where you don't have a hearing. So it's clear, let's say you get a case where it's clear that the person committed a gun crime. Look, all of my clients are innocent. I never get any clients that aren't innocent. But hypothetically, tentatively non-binding, I get a client that's clearly not innocent.
Okay.
They clearly improperly use their firearm. They're facing 3 years minimum mandatory on a gun charge or 15 years on a gun charge. We're not going to make a big stink about the RPO. Like, you're not going to go to court and challenge an RPO when the guy's sitting in jail looking at 15 years on a gun charge.
And you get cases like that?
Oh yeah, all the time.
Really?
So what you do is you just agree to the RPO. So you just say, look, fine, put the RPO in place for a year. The guy's going to be in jail for a year anyway because of the charges that he's pending or whatever. So you don't waste your time fighting that, because what you want to do is fight this. You can also get other ones where there are legitimately people who maybe having mental health breakdowns or issues going on in their life, and they try and kill themselves with a gun or whatever, and they get Baker Act and they get out and they're still going through a lot of treatment. There's no reason to have a hearing on that person because usually they don't want their firearms back, and they probably shouldn't have their firearms back. And you know you're going to lose it because you're looking at a report from the medical facility that says this person's crazy and shouldn't have a gun. So again, you just either agree to it. It's supposed to be a year. Sometimes you can agree and negotiate that it's only for 6 months. So I have either negotiated to what I believe is successful terms for my client on those, or I've won them at a hearing.
What about animal attacks? What's the rule you see a fucking coyote down Bee Ridge?
So I mean, it's basically
Eating
the
a cat.
same rule. If you are in fear, you can shoot them. So I mean, if you're just driving down Bee Ridge and you see a coyote, you can't just go, oh, cool, and pull over and then get your gun out and shoot the coyote. If you're walking your dog in your neighborhood and a coyote comes out and looks like they're going to attack you or your dog, then you can shoot that coyote in defense of yourself and your dog. It's not even just a coyote. Like, you can technically shoot your neighbor's dog or whatever. Like if they jump the fence and they're coming, they're attacking you and they're attacking your dog, you're allowed to shoot them in defense, just like everything else. Pets are considered property in Florida. I know there's a lot of people that think that they're their babies and they're just like their real children, but theoretically pets are property in Florida. You can't be cruel to an animal. So again, if you just see a dog walking down the street and for the shits and giggles you decide to shoot the dog, you're going to get an animal abuse charge or cruelty towards animals. But if they're legitimately attacking you or your dog or your children or whatever, and you're in fear, you can shoot them if you want to. What I recommend, though, is not only should people carry firearms, but you can also carry non-lethals. Bear spray works great on dogs. Pepper spray works great on dogs. So if you're walking your dog late at night around your neighborhood and you want to carry your firearm, that's great. But you should also carry some sort of non-lethal, because those things usually work better in those situations. Then you don't have to deal with whether you got cruelty to animals or anything along those lines because you've used the spray.
And then cops come and you lose your firearm.
They probably wouldn't do it if you shot a dog. They might, though. Again, it depends on it depends on the situation. If they come out and there's no evidence that the dog was threatening you, you may have a problem. They could charge you with cruelty to animals and take your gun.
What's the craziest gun case you've had to represent that you can speak about?
I mean, probably the one I talked about before was the craziest, only because it was clearly on video and they still arrested the guy. I mean, I've had drive-by shooting cases. I've got a murder case going on right now, which is a drive-by shooting case, which is interesting. Here's the funniest, not the craziest, but like the weirdest firearm type story I'll tell. So a robbery takes place. 3 guys come up on a party of a bunch of people drinking, et cetera, et cetera.
This is in Florida, of course.
In Florida, yeah.
Right
they all
here.
jump out of their car. They're all holding rifles of some sort. One guy's got an AR. Another guy's got like a pump action, like a full regular shotgun. And another guy's got a shotgun that's got a pistol grip on it. So they jump out. They rob all these guys.
At the party.
Okay.
Okay.
They end up catching all 3 of these guys. I'm not going to get into all the details about how, but they end up catching these 3 guys. The 2 guys, the one guy with the rifle, the AR, and one guy with the full stock shotgun, ended up pleading. They got like 30 years in prison or 15 years in prison or something like that. I ended up representing the 3rd guy. Nobody knew who this 3rd guy was. So the problem is these first 2 guys were friends of the people in the group. This is what always happens. People don't rob strangers. They rob people they know.
Oh.
And then when they get picked out of a photo lineup, they're like, well, how did I get caught? Well, because they fucking know it's you because they've known you since you were like in grade school. It happens all the time. It's crazy that you always rob the places you know. And so they knew who those 2 guys were. But the 3rd guy, nobody had ever met him before. So nobody knew who he was. Nobody kind of picked him out of a photo lineup. They sort of thought he was the 3rd guy. But they didn't really have enough to charge him. Well, he's in jail, and he starts talking to his cellmate. And never talk to people when you're in jail. Don't talk to people on the phone because they record all those phone calls. Don't talk to your family members or anything like that. They get recorded. And don't talk to your cellmate because every single one of them will roll over on you in a heartbeat in order to get a lighter sentence.
I told you, Dean.
Yeah, don't ever do that. So they get into jail, and he allegedly makes kind of like this confession to his cellmate. And he says, yeah, I was, there were 3 of us or whatever, and Johnny had the shotgun. These aren't their real names, but Johnny had the shotgun, Billy had the rifle, and I had the pistol. That's how he said it. I had the pistol. Go to trial. Every witness gets up there and says, 2 shotguns and a rifle. 2 shotguns and a rifle. I asked, anybody have a handgun, like a Glock or a handgun or like a pistol or whatever? Nope, nobody had a pistol. Everybody had rifles and shotguns. Great. Cops get up there. They have the shotguns. They introduce them into evidence or whatever, and everybody says shotguns, rifles. The jail guy gets up there. What did he say? Well, he said he had the pistol. So what did I do? Ladies and gentlemen, you can't believe the guy who's in the jail cell because he said my client confessed to having the pistol, and everybody on the stand said there were no pistols. There were 2 shotguns and a rifle. We all know when he says, I got the pistol, what's he saying?
Pistol grip shotgun.
He's got the pistol grip shotgun. But the prosecutor doesn't know that because they don't know guns. The detective doesn't know that because they don't know guns. And the people at the party don't know that because they don't know guns. So I got to basically dismiss pretty much the only evidence they had on this guy because nobody knew the terminology about firearms. And I harped on that through the whole case and through closing argument and said, nobody had a pistol, therefore he's making up my client's confession. He was found not guilty. That guy sat in jail for 2 years. He was wearing handcuffs on his legs. Jury comes back not guilty. They take the handcuffs off his legs. He walks out of the jail scot-free. He gets out on the courthouse. He does like the Rocky, woohoo, oh my God, I haven't seen the sunlight in 2 years. All because people don't know
terminology.
Guns. People don't know guns.
Wow.
And
People
the
don't know
other 2
guns.
guys got 15 or 30 years or something.
Yeah, and the other 2 guys, they were screwed, though, because they had evidence against them. But, yeah, those 2 guys got 15 or 30 years, and my guy walked out of the courthouse free. Again, a lot of it was because they didn't have great evidence against him, but the best evidence they had got thrown out because they don't know terminology. And this is what I keep telling people is cops don't know guns and they don't know gun laws. Prosecutors don't know guns and they don't know gun laws. Judges don't know guns and they don't know gun laws. And so, and most other lawyers out there don't know guns or know gun laws. So if you get a gun situation, you should always call somebody, whether it's me or somebody else. I'm the only one local, Minnesota gun lawyer, who knows about
The shameless
gun
plug.
stuff.
The shameless plug.
That small little detail could mean the difference between life in prison and walking out on the street.
30 years.
And I've offered the state attorney's office, hey, I'll come in and teach people. I'll send them to, Veritas for training or whatever. Your people should know gun laws. They won't take me up on it. They don't care. So it's good for me because it lets me keep getting people out of cases. They've had cases thrown out because they've tried to claim that somebody was in possession of a firearm and it was just like the slide. They didn't have the grip with the trigger or nothing on it. It was just a slide, which doesn't meet the definition of what the firearm is. And so they've gone to trial on that, and the judges threw those cases out. Like they don't know guns, which is scary because that's how you end up getting arrested and charged because they don't know guns and gun laws. But it's also could end up being good because if you get a good defense attorney who does know guns and gun laws, then you can get your case thrown out.
Dean, do you have any questions for Jeff? Is there anything you're dying like, oh, fuck, we have a lawyer, finally?
No, I mean, he's given great information. This is packed full of facts. I love it.
Yeah, and Luke, what about you?
This goes back to the brandishing thing.
You guys like are you guys planning on like walking down the street waving your guns around or something? Jesus Christ.
No, I think we all have I have PTSD from the amount of hate we got on TikTok.
Yeah.
Fuck yeah, man.
I hear you.
So say I'm at the store and my shirt comes up a little bit and someone sees that I'm carrying a concealed firearm. Well, I guess it isn't concealed at that point, but it's accidental.
Right.
Can you still be charged with the improper display?
No, they actually changed that law. I want to say going on maybe 8 to 10 years ago. You used to could be. You're reaching up on the top shelf, your gun gets exposed. Theoretically, back then you could have been charged with it. But they've kind of fixed that in the law now, and printing is legal now. It used to be if you printed, you could get in trouble, but you can print now. If it's an incidental, is what they basically call it, an incidental display, that's not going to be covered because improper exhibition still requires it to be like in a reckless or improper manner.
Right.
And doing that is not in a reckless or improper manner. So it's not going to be, you'll be fine if that happens to you.
All right.
What about you, Pierce? Do you have any dying questions for the lawyer?
No, I'm good.
Great.
Sweet. Is your time for free advice? Everything else would be $250 an hour.
It's $250 an hour, man.
Have you ever had like anyone use an NFA item in self-defense or do you see
what
that
happens
a
to
lot?
that?
Yeah. No, I've actually never had anybody do that.
Is it illegal to use an NFA
No.
item in self-defense?
Nope.
Oh, that's a big one right
No,
there,
there's
right?
no special statute about that. I had an NFA case. So back before the braces were illegal or whatever, we all knew that they were the opinion was that they were legal. The letters had come out and
Correct.
said they're perfectly
Yeah.
legal. Everybody can have them. All the stores were selling them. They were legal. So I did have a kid who was driving down the street, and this is why you don't cooperate. So he's driving down the street. He gets pulled over for like speeding or whatever, and they ask him, "Hey, do you have any guns in your car?" And he says, "Well, yes, I have a couple of guns in here. Do you mind if we look at them?" Sure, no problem, because he thinks he's not doing anything wrong. So the cops go through his car, and they find a couple of handguns, and they find a pistol with a brace on it. Mm-hmm. And they arrest him and charge him with possession of a short barrel rifle. Even this was like 5 years ago before all the laws changed,
That
and
was
they
in
charged him.
Venice, I remember that.
Well, I won't say neither here nor there where it was at, but he was charged with it. And not only was he charged with an SBR, I had the dash cam video of the cops. They didn't know nothing because they're telling him he can't have the bullets basically where his gun is. He's not allowed to have this many guns in the car. Like everything they were basically saying about the law was wrong. And
Just
so they
making up
charged him with
shit.
that. Yeah, basically they charged him with that. I believe I did contact you guys when that case came out, and you put me in touch with the guy who actually designed and built and built the thing. And we ended up having a conference between me, the supervisor at the state attorney's office. I had the manufacturer of the product on the line, his lawyers. I had a representative from the NRA. I had a lobbyist lawyer calling from Washington, D.C., and we were all on the line basically trying to tell the prosecutor it's legal. Like, I gave them all the letters. I gave them all the, look, every gun internet site says buy these, buy these, buy these, buy these. But they had sent the gun to ATF, and ATF sent a report back that said it was a short barrel rifle. Ooh. At the same time that they were sending out the letters saying they're not short barrel rifles. So even back then, they wanted them to be SBRs. It just took Biden getting in there to kind of change the law. So
what happened to the client?
Well, the charges were dropped. We were all able to convince them that the charges should be dropped. They dropped the charges, and he got his stuff back. And then 3 years or 4 years later, Biden says you can't have them anyway, and they become illegal. So, but that's the kind of stuff that happens. I get videos all the time of cops on there talking about laws that don't exist. You got to keep your bullets separate. I saw a video where a cop was telling a person they had to follow the 3-step law, which doesn't exist. It's a fake law that never existed in the state of Florida, and people are still walking around, including law enforcement, telling people that Florida follows the 3-step law. I was in another gun shop. I will not name the gun shop. It wasn't this one, where the guy behind the counter was telling a customer Florida follows the 3-step rule, and that's how you can carry your firearm out there. So there's a lot of misinformation out there about firearms.
Yeah, what's the dumbest myth about firearms from a legal standpoint that you've come in contact with, or that you can say?
Yeah, I would say number one, the 3-step rule is the biggest myth. The other myth is if you shoot the guy on your porch, just drag him in your house, because if he's in your house, you're good to go.
Have you represented?
That's not how that
like
works. I've never represented anybody who shot somebody outside and dragged them into their home.
Do you know anybody doing that?
No.
Okay. So you can't shoot somebody and drag them.
Right. Yeah, people, if you shoot somebody outside, just drag them in your home. The other biggest serious myth, those are kind of jokey ones, but the biggest serious myth is that you can use deadly force to protect your property. A lot of people will be like, oh, if I see guys in my driveway breaking into my car, I'm coming out, blazing or whatever. I'm pointing my gun at them. You can't do that. In the state of Florida, you cannot use deadly force or the threat of deadly force to protect property. So if somebody's breaking into your car, you see somebody shoplifting from Walmart or whatever, like, you cannot shoot those people. It has to be imminent fear of death or great bodily harm, or to prevent a forcible felony.
Isn't that presenting a forcible felony?
No, if they're breaking into an empty car, that's not a forcible felony. That's a burglary.
So what if
now, if it's an occupied car, there's people in the car, then it could be a forcible felony, because now you're talking about either carjacking or a robbery or whatever. So it's still going to be fact specific. But if you're breaking into an occupied car, the person inside the car has the castle doctrine that extends to them, so they can use deadly force. If you're outside the car, you can use deadly force or threat of deadly force, most likely at that point to prevent the forcible felony of the carjacking or the robbery or whatever's going on inside the car. But again, you got to be everything's going to be fact specific. I can sit here and tell you that this is what the law says and this is what the law says, but again, all it takes is one detective or one prosecutor,
and you can still get arrested.
To think that I don't care if that's what the law says.
So
and off you go.
ATM getting robbed, that would be forcible felony.
Correct. That's a robbery. Yeah.
Okay, so if you're getting robbed, you can.
Yes, robbery is a forcible felony.
So the key word there is forcible felony.
Correct. And there's a list. So if you just if you go to Musings with MGL, I actually did a video, I want to say 4 or 5 months ago, where I kind of laid out what the forcible felonies are, and I went through the statute and the language. There's a list of them in there. Number one is treason. For some strange reason, it's like treason, murder, arson, kidnapping, but treason's at the top of the list. So. Right. Yeah. Yeah. There's a definition of treason in there. So don't just be like, if Nancy Pelosi comes to Florida, we have forcible felony. Well, that's not how it works. But there's a list of them in there. So go learn that list. And then again, it's all going to be a gray area. If you see somebody beating a woman outside of a 7-Eleven, that's technically a misdemeanor domestic battery. It's not forcible felony. But if you injure a person while you're beating them, it could be bumped up to a felony, because now there's injuries. Or is he trying to kill her? Is he choking her or whatever? So a lot of that stuff's still going to come down to a gray area.
Stabbing.
Well, yeah, that would be an aggravated battery,
yeah.
right?
But
or attempted murder.
like you were saying, like the property thing, like the car in the driveway, and you said my dog is property. So if my dog is out front and someone ran up to harm, let's say stab my dog, and I'm inside, I can't defend my dog with my firearm.
Well, my gut instinct is going to say no.
Yeah.
I don't have. Go look at the definition of forcible felony, and I mean I can look it up real quick and see if animal cruelty is in there. I don't know all of them off the top of my head, but let me. Google can be your friend. I never tell anybody don't follow Google lawyers or Facebook lawyers are the worst, but you can certainly find the statutes in the Google. So let's see. Forcible felony means treason, murder, manslaughter, sexual battery, carjacking, home invasion, robbery, burglary, arson, kidnapping, aggravated assault, aggravated battery, aggravated stalking, aircraft piracy, unlawful throwing, placing, or discharging of a destructive device or bomb, and any other felony which involves the use or threat of physical force or violence against any individual. So no, I would say your dog's not going to count.
Yeah.
What about Kamala Harris? Do you think she's hot?
Oh.
Good answer.
Good answer. Hey, so we're going to call it. We want to thank Jeff Young from Minnesota Gun Lawyer for coming down. I can't say that we won't invite him over here the next time we have a legal quandary. He definitely gave us a bunch of advice. If you watch this video, we appreciate it. Thank you very much. It's a way that we can get our digital footprint spread around the internet because Facebook is censoring us and social media censors us. YouTube a little better. And so we use this platform to better our company and better ourselves. You can check us out, sharkcoasttactical.com. Smash the like button, follow us, tell your friends about us. Go to Instagram, check us out, Shark Coast Tactical. Facebook, it's SCT Laser and Customs because our big Facebook account got nuked. And I thank you for watching. Jeff, thank you so much for coming.
You're welcome.
Don't leave me hanging.
Go to Musings with MGL on YouTube and get my subscriber numbers up. That'd be great. Appreciate it.
Yeah.
Thanks, guys.
Nice to meet you guys. Thanks a lot. Look forward to coming back.
See you next time.
Peace.